Hi, this is Marnie Carter, back with you to talk a little bit more about the new California Electronic Discovery Act. I was speaking of the idea and thought of accessible versus inaccessible information and how it is articulated in the federal rule amendments and the California Electronic Discovery Act. I want to talk a little bit more about the comparison between the federal rules amendments as well as the California Electronic Act in terms of claims of privilege and the idea of safe harbor. So under Federal Rule 26B5, claims of privilege can be asserted after an inadvertent production. And in this case, if information is produced to a claim of privilege or work product protection, the producing party can right away notify the receiving party of this fact along with the basis of the claim. But the receiving party must return or sequester or destroy any of that information in which a privilege has been asserted. The producing party must preserve the information, however, in case that information is deemed to have to go before the court for an in-camera review. California, additionally, in its new Electronic Discovery Act, provides for the return of inadvertently privileged information. It is similar to Federal Rule, Civil Procedure Rule 26, subsection B, subsection 5, in that the party that received the information must sequester it or return it or make a motion within 30 days. This is somewhat different than the federal rules of civil procedure that say that this claim must be made within a quote-unquote reasonable period of time. California actually articulates the 30-day requirement under California Code of Civil Procedure section 2031.285. The receiving party may not use the information revealed through the inadvertent production of the privileged documents, and we additionally see this mirrored in the federal rule amendments. When we meet next time, we'll talk a little bit about the requirement to meet and confer under the federal rules of civil procedure and how that was interpreted with the California courts and the California Electronic Discovery Act.